Hi, I'm Gretchen Gould, and today we're at the Judicial Barnyard to learn about the Supreme Court case of McCreary County versus the ACLU of Kentucky. Let's first learn about some of the background of this case. Let's go talk to some of the citizens of the Barnyard of the Supreme Court to find out more about the background and the history involved in this case. Who exactly is the ACLU of Kentucky, and why are they trying to sue McCreary County?
Well, ACLU actually stands for the American Civil Liberties Union of Kentucky. The ACLU often goes and finds litigants to support in defense of civil liberties that need to be brought to justice.
Oh, well that makes sense then why they would sue McCreary County. Because they didn't think it would be just for McCreary County to be displaying such a religious document like the Ten Commandments. Let's see if our other old and wise correspondent has any advice or other things he'd like to add in on this case's background.
Well, Gretchen, McCreary County would never have occurred now, unless it had been for many cases before that happened, and many things being developed before, such as the lemon test.
The lemon test? What's that?
That religious relics have to have secular purpose.
Thanks, guys. I think I understand this case a lot better now. Thanks for your help. Those two wise old horses also told me something else very interesting. Many other new cases like this had been occurring recently, such as another case that came up recently was Van Orden versus Perry, where a homeless atheist lawyer sued the Texas government for a statue that was on the Texas Capitol's property that had been donated. But the statue is very old, so the Texas government actually won in this one. Also, the statue was in a group of statues that was not seen as religious. Now that we've learned about the background of the ACLU versus McCreary County in Kentucky, how about we find out what each side thought of the case? I'm here with a very knowledgeable ACLU member. Let's find out what he thought of the case. That even though documents like the Ten Commandments are influential as documents like the Magna Carta, there's no reason for religious displays to be more significant in public historical displays. The ACLU also thought, even though that the Ten Commandments play an important part in the spiritual lives of many Americans, and it is precisely for this reason that the government should not be in the business of endorsing or promoting religious beliefs. And so, even though the majority of America has no problem with these religious displays, it is the government's job to fully include, protect, and represent the minority citizens to the same extent as the majority citizens. The act of McCreary County putting up the Ten Commandments in their courthouse was unconstitutional because it violated the First Amendment clause. I have an expert here from McCreary County's argument. Let's see if he can tell us a little bit about McCreary County's argument in this case. McCreary County was misinterpreted and misrepresented in court. The display that McCreary County put up was much like a museum display, where many random and donated artifacts and documents are constantly being changed and rearranged. The McCreary County Courthouse saw and interpreted the case as secular and not any endorsement of religion, since the documents are often viewed as a part of our nation's history. McCreary County is also very concerned that if the ruling was retroactive, lots of historical documents would or could be destroyed. Now let's find out what some of the justices thought. Justice O'Connor said that she voted for the Ten Commandments to not be able to be posted in a courthouse because due to the fact that it would send a message to non-religious people that they didn't belong and were less significant in government. Justices Stevens, Souter, Ginsburg, Breyer, and O'Connor made up the majority opinion that decided that it's not constitutional to display documents like the Ten Commandments that are endorsing religion and government that ought to be religiously unbiased. Justices Rehnquist, Scalia, Kennedy, and Thomas made up the dissent. Justice Rehnquist saw these documents as being acknowledgement of our country's history. All justices did make good points, but let's find out if their stereotypical votes led to the right decision for our country. I'm here with law professor Erwin Kerminsky to find out what he thought of the Supreme Court's decision on this case. The decision made in this case have not helped clear up confusion on the matter of religious symbols for the lower courts at all. I'm here with writer Jacob Rolls. What did you think of this decision, Jacob Rolls? Judiciary review system was a success in this particular case because it was able to peacefully and nonviolently and intelligently settle a dispute between McCreary County and the ACLU of Kentucky. I disagreed in this case because the role of the judiciary system is to create national standards and decisions. So, in my opinion, in this case, the judiciary system would have failed. Wow, I've learned so much at the judicial barnyard. I think this decision was the right one for the country because it solved this dispute in a nonviolent way. And also, it's important to keep in mind what Justice Breyer said. The court has found no single mechanical formula that can accurately draw the constitutional line in every case. In solving this dispute, the judiciary system accomplished its main goal and did the best thing for all Americans and not just the majority of Americans.